All right, in this court, communication is key. If there's an issue, pick up the phone, call your probation officer. If you feel as though they're not addressing it, you can always come back to this court, okay?
A first-time offender, a state jail felony drug charge, and a chance at deferred adjudication. But the court is about to decide if this is a second chance or the start of something worse.
Hello.
Hi.
Hi. I'm sorry for us. We were intending to get you on the docket last week, but there were some issues. So I'm sorry for that.
Oh, that's all right.
All right, court is calling 2024 CR 2208, State of Texas versus Amoya Lewis. Could I have parties announced for the record for the state?
Jason, go ahead.
Defense?
Your Honor, good morning. Frankie Sandoval on behalf of Ms. Lewis.
And are you Miss Lewis?
Yes, ma'am.
And how do you pronounce your first name?
Amoya.
Oh, okay. Counsel, have you received all the discovery? Did you review it with your client?
I have, Your Honor.
Court will find the state is in compliance with discovery. Ms. Lewis, I'm showing you what's entitled application. Okay, sure. Just give us 1 second.
Okay.
It's nice to know it's not only my software that gets glitchy.
All right, no problem. Showing you what is entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your
Does Ms. Lewis have priors?
Honor. Your Honor, not that I'm aware of.
Do you have any prior convictions?
No, ma'am.
Is this your first case?
Yes, ma'am.
All right. Could I have attorney's approach?
Thank you, Judge.
Trespass. In 2018, was on probation for the trespass. And the Torres Heights on the trespass again. And then again in 2022.
All right. All right, no problem. You're welcome. All right, I'm going to show you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? It's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Okay.
Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any, just 1 second. Counsel, has your client been able to provide you with any defenses to this offense?
We have discussed possible defenses. Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Judge.
Ms. Lewis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine to be probated. The state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Next, I'm showing you outside the agreement. State is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 100 hours of community service restitution, and a referral to felony drug court. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State Exhibit number 1 with all its attachments.
No objection, Judge.
All right, state, you may continue to confer. Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And
Yes.
did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
In the interest of justice, we would ask so, Judge, so that the TAP evaluation can commence as soon as practical.
All right, anything you wish to say on behalf of your client?
Your Honor, Ms. Lewis presents herself here. She's been a pleasure to work with, and once we went over the facts of the case and her options, she accepted the responsibility and wishes to seek assistance so she can start putting this behind her.
All right, Ms. Lewis, do you have any support system?
Yes, ma'am.
Who would that be?
My godmother.
Okay, and where are your mom, your dad?
Currently in California.
Okay, so how did you end up in San Antonio?
My mom brought me here and just to finish high school.
Okay, and who did she bring you here to finish high school with?
And just herself.
Okay, why?
She had just exited the military
Mhm.
and wanted to find a place to station, and she was choosing here.
All right, and when's the last time you had contact with your mom?
About sometime last month.
Okay. And have you ever had a mental health diagnosis for anything?
Yes.
What for?
Bipolar disorder.
Anything else?
And psychosis.
Okay. Do you have any children?
No.
How old are you?
27.
How far did you go in school?
High school.
You graduated?
Yeah.
And have you ever had any employment since high school?
Yeah.
Doing what?
Working at a chicken processing unit.
Okay. All right. So how often, well, when did you start using drugs?
Just recently, sometime last month.
All right. This is what the court is going to do. Court is going to sentence you to a $500 fine. That would be probated. 2 years deferred adjudication. A referral to felony drug court while in custody. Because it's Monday, they should be able to get to you this week. And even though, Michael, if you could move out of the line of sight of probation. And even though they may be full, they're about to have a graduation, so there may be some openings, okay?
Okay.
There's to be regular reporting by Zoom or in person. Regular random UAs. Field visits. 1 time per month. until in treatment, TAP evaluation in custody, MIC evaluation out of custody, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. A referral to Center for Healthcare Services. If she's in felony drug court, they'll take care of that. Probation, I'm sorry, in 90 sober meetings in 90 days. Probation, is there anything, y'all need to get out of the line of sight of probation. All right, probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. So both defense counsel and the state have told me that you've had some criminal trespass issues in the past.
Mhm.
If you are homeless, let probation know, because they'll be able to give you some resources that can find a place for you to stay. But you cannot be picking up criminal trespasses. You understand?
Yes, ma'am.
All right. Is there anything else you need from the court to be successful?
No, ma'am.
All right. In this court, communication is key. If there's an issue, pick up the phone, call your probation officer. If you feel as though they're not addressing it, you can always come back to this court, okay?
Okay,
All right, good luck to you.
thank you.
And Your Honor, in that regard, would the court happen to have a card so I can give to Ms. Lewis?
Oh, probation is going to speak to her.
Okay,
Yes.
we do appreciate the courtesy extended by the court judge.
Oh, thank you so much. It's always a pleasure to see you.
Take care, Your Honor.
All right, have a good one.
Here, Ms. Lewis.
All right, court is calling 2022 CR 11241, State of Texas versus Jose Torres. Can our parties announce for the record for the state? Defense?
Adam Torres for the defendant, Your Honor.
Are you Mr. Torres?
Yes, Your Honor.
All right. I have on the docket that you all had a competency trial. Did you complete that?
Yes, Your Honor. And the court found him competent, Your Honor.
All right. So then the next thing we have is we're here for sentencing. According to the plea bargain agreement that was entered on April 3rd, 2023, the defendant pled no contest to count 2, count 3, and applied for deferred adjudication. The state was silent on your application. Are you all ready to proceed with sentencing?
Your Honor, please the court, Your Honor. I was not the original attorney that was assigned to the case, Your Honor. And we discovered new evidence, Your Honor, and I asked the state for discovery. And she says she has not received it yet.
What new evidence?
Well, allegedly, there's some body worn camera from when the arrest was made. It's an at-large case, so it was like a separate thing. I requested body worn camera from the number that I was given by Mr. Flores, and I never received anything back from it.
All right. So is there body camera footage?
Not that I know of, Judge, but there could be. The only way I heard about this is him saying that his client saw body worn cameras when they came in.
All right. So the court is going to go forward with this sentencing. This has been going on since April 3rd, 2023. All right. Have both parties received the PSI report, state?
Yes, Your Honor.
Your Honor.
Defense? Anything you wish, any corrections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I read the PSI and the victims are asking for probation, Your Honor. She will not object to a probation, Your Honor. We're asking for probation, Your Honor.
All right. Anything else you want to say on behalf of your client?
No, Your Honor.
All right, the court is going to deny the application. The court will find you guilty in counts 2 and count 3. Is there anything you wish to say, Mr. Torres?
Your Honor, if you could give me a second chance, I'm so sorry if anything.
I'm sorry.
I'm
You
so,
want to raise your right hand?
I'm sorry.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Jose Torres.
All right, there's something you wish to say?
Yes, Your Honor, I just wish you give me a second chance. I I was, everything was good. I was working 12-hour shifts at Toyota and it just, everything just fell apart. Just wish you give me a second chance, Your Honor.
All right, court is going to find you guilty in counts 2 and count 3. Is there any questions from either attorney?
No, Your Honor.
No, Your Honor.
All right, the court will follow your agreement. Court is going to sentence you to 4 years TDC in count 2 and 4 years to TDC in count 3. Counts 2 and count 3 will run concurrently. There should be Chapter 62 compliance and no contact with the complainants. And there'll be credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. All right, good luck to you.
Thank you. Am I excused?
Yes.
Thank you.
All right, so today is the plea deadline date. Is he accepting the plea or requesting a jury trial?
No, Your Honor. Just confer with the ADA, and the ADA is requesting an opportunity to bring in the other witnesses and to question them about what they know about the incident. Right now, as it stands, looking at the elements of the offense.
Well, I'm not want to get into the elements. So my question is, do y'all want a jury trial? What's happening here? Because the day is supposed to be the plea deadline date.
Again, Judge State's made another offer. We've given it to defense counsel. Defense is asking that we reach out to some of the witnesses, which I told them I'd be more than willing to do. At this point, just one short setting, and then we should be able to have a better answer.
All right, the court is recalling this for April 11th. That will be your final plea deadline date. There will be no further extensions of plea deadline dates.
Thank you.
Okay.
All right, is there anything else?
So, yeah, maybe we be excused, Your Honor?
Yes. Thanks, good seeing you. Have a good one. Court is calling NYMAG number 751772, State of Texas versus Luz Eduardo Briceño. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Joseph Holster.
Are you Mr. Briceño?
Yes, Your Honor. Yes, Your Honor.
All right, we're here on a motion to modify conditions of bond to remove the GPS device. State, have you had a chance to review the
We
document?
have reviewed, yes, Your Honor.
Do you have objections?
We do, Your Honor. We are not in agreement with that, but I believe defense has a modification of their motion to, which they'd like to take with the court.
Yes.
State, yes.
So, Your Honor, Mr. Briceño works in construction. So the device is burdensome to him and we are asking that it be removed, but alternatively, what we would ask is the court's assistance in dealing with the pretrial officer. Mr. Briceño is on partial house arrest right now. I literally thought he was on full house arrest. The pretrial officer has been so aggressive that Mr. Briceño lost a job he had just started when he contracted with me because of contact between that employer and the pretrial officer. The pretrial officer, I've spoken to him twice. He's one of the rudest people I've ever dealt with from the county. He threatened to violate my client when our consultation ran a few minutes late. He would not give us more than an hour to meet. He called in the middle of our consultation to verify that my client was physically present, despite the fact that he can tell my client's physically present because of the GPS monitor. It is incredibly burdensome to my client. So if you could just leave him monitored and remove the partial, that would solve our problem. But I don't know what's going on with pretrial. My client's been nothing but polite to me, and I can tell you, I've been nothing but polite with this pretrial officer.
All right, who's the pretrial officer?
What's his name?
Joe Garcia.
All right, talk with Ms. Ferguson. We'll have them zoom in.
Thank you, Your Honor.
All right, thank you. Just have a seat. Are you all ready to proceed on this motion?
Well, Your Honor, in the state, will confirm, Mr. We were here on we really just wanted to weigh in with the court to see how the court wanted to proceed.
All right, what's happening?
What's happened, he was released from custody here in Bexar County on the 17th of February. He has an MTR in Guadalupe County. He's being supervised through Guadalupe County on the probation from Bexar County.
Mhm.
And I guess to get to the gist of it, they're considering safety in Guadalupe County, but they couldn't make that decision until this case was resolved.
All right, so what are y'all asking for on this case?
Well, there's a recommendation, Judge.
For a motion to withdraw the MTR and then to monitor the case in Guadalupe.
Which would give time for. So he would still be on probation here, Judge. And we would state to the court, everything the court told him to do since then, he has attended the meetings that the court asked him to attend. He has passed his drug test.
All right, did you do a drug test today?
And he has not done one today, Judge.
Are you ready to do a drug test today? All right, we'll do a drug test today, then we'll see where we are.
Yes, ma'am.
Court is calling 2024 CR 0289, State of Texas versus Oscar Olvera. Could I have parties announced for the record for the state?
Jason Gary.
Defense?
Jerry Valdez Jr. from Mr. Olvera.
And are you Mr. Olvera? And probation, there is an application. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Olvera, showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Mr. Olvera, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with unlawfully carrying of a weapon with a felony conviction? That is a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Olvera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $2,500 fine. No application for deferred adjudication. State recommends community supervision. This is to run concurrent with 719380. The state will take in consideration 2024 CR 3577. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 220 hours of community service restitution, no contact with Angelica Donez, Donez, and Jose Garza, or the location at Artego Street, Artego. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
No objections, Your Honor.
All right, states, you may continue to confer. Showing you do y'all have the dismissal? Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. He's been in custody 171 days, Judge. While he's been in custody, he has been taking drug counseling classes. He's finished the cognitive skills course while he's been in custody, Judge. And we're asking the court to grant him probation, but we still have that County Court 11 case that he needs to take care of, hopefully today, if not this week.
Okay. All right. When's the last time you had employment?
Well, right now, I mean, I wasn't employed, but I was looking for a job. So
How long have you been without employment before being taken into custody on this date?
Like 6 months.
All right. So according to this, you were looking for your children?
Yeah.
That's either yes or no.
Yes, ma'am.
All right. And how old are your children?
12 and 11.
All right. So you hadn't been paying child support for them, obviously, because you didn't have employment, right? Before you go looking for your children, you need to have your life in order. You understand?
Yes, Your Honor.
All right, this is what the court is going to do. Court is going to sentence you to 10 years in prison, suspended and probated for 10 years. There's a $2,500 fine that is to be probated. This is run concurrent with 719380. Take in consideration 2024 CR 3577. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. The MRT course in a parenting classes. 220 hours of community service restitution. That will be waived upon completion of the parenting classes and MRT. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be no contact with Angelica Donez and Jose Garza. or the address at Ortega Street. You're just not allowed to go on Ortega Street, Artego. Do you understand?
Your Honor, I understand. They are neighbors. He's been staying there with his father, so I told him he's gonna have to avoid that family, but he does live there.
State, you want to address the issue with the no contact?
Well, Judge, on that particular address, 326 Ortega, he went onto that property.
Okay,
We prefer at least not to enter that property or even not knock on the door or anything like that.
all right, so there's to be no contact with that property. Do you understand?
Yes, Your Honor.
There's to be no unsupervised contact with minors. There's to be field visits one time per month for 3 months. Then at probation's discretion. Probation, is there anything else he needs?
No, Judge.
Is there anything else you need from the court to be successful? I'm sorry?
No, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let probation know. If you feel as though they're not addressing that issue, you can always come back to the court. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Your Honor. Excuse, Judge.
Yes.
Final outcome. Allah receives a 10-year sentence, suspended for probation, along with strict conditions including classes, employment requirements, and no contact orders. It's a major second chance, but one mistake could mean a decade behind bars. Like, share, comment, subscribe.
Your Honor, if the court's inclined to hear from Mr. Hernandez, he would like to offer an explanation that I think he'd be more apt to explain to the court than myself.
All right, so here's the explanations that are not going to help you. So let me just start with them. One, it's really a false positive because there's nothing. Two, I ended up touching something. That's not going to help you because you know what? When you touch items, then maybe you're not just using. So what explanation are we going for?
So even the ones that I felt previously, when I had the patches on, I never felt them back to back. And it does make sense what you're saying, but at the same time, I'm expected to sweat into the patch and comes off right away. Y'all put another one.
No. We're talking about this.
Oh yeah, I know. I'm just saying, never felt them back to back. Then it always felt for some reason. I know I have friends that do it on my softball team, and I always felt the ones that I felt were always after that. So I don't know if it's because maybe I drink water after one that does or what, but
why are you hanging around people on a softball team who are doing drugs?
I mean, I stay away from them, but except for when we're on the field and that's it. But it's just, I know I was a little nervous to take this test because I had a feeling because I played Saturday and that's what but I believe that maybe the patch was stronger.
People just doing cocaine on the softball field.
Yeah,
Okay.
you'd be surprised what they get. That's pretty crazy. But yeah, I mean.
Hopefully this
that's
is
only
not
my
church
explanation.
softball team.
No, ma'am. No,
Okay.
ma'am. It's not.
I didn't think it would be.
No, ma'am.
All right. So are you all still wanting to do this?
Well, Your Honor, procedurally speaking, where we are is there in Guadalupe County. We have the MTR that was moved to the 23rd of May. The reason it was moved is because there was a recommendation for safety, but because this case was still open, they couldn't do that. And so they said we'd come back here today. It was our hope that the court would consider continuing him today or withdrawing it, which is aligned with the recommendation. But of course, new things have come to light. And so at this point, we're kind of just yielding to the court in terms of what posture the court would like to take moving forward.
All right.
Given this, given the new developments. Judge.
All right. if you all want to have the motion to revoke heard, I'm inclined to have him taken into custody and he can be interviewed for felony drug court. And then if y'all will let the other county know that he's in felony drug court.
If I could just have the
Sure.
time to speak to him, Judge.
Morning, Judge.
Good morning. So what are we doing on this case?
Your Honor, previously, the state had given to me a body cam video that I was requesting for a while.
Mhm.
It is on a hard drive. I have failed to review that hard drive.
Okay.
I'm asking for just a little bit more time. I don't know if we want to reset it for this week or next week, maybe Thursday, April 11th.
Okay. All right, we can bring it back on April 11th and
Is that all right?
April 11th. It's on Arnett, Andrew Arnett. And state, did you make an offer?
Sorry, you didn't confirm with me. Did we make it all?
I think
Yes,
you,
Your Honor.
okay.
Yeah.
All right, so this will be your last plea deadline date. It's going to be April 11th. Okay.
That'll work, Your Honor.
All right, is there anything else?
Not in this case, no.
All right, once you sign the reset form, you're excused.
Thank you.
You're welcome. All right, so today is for discovery and an offer.
So, Your Honor, we are making good progress. Just to kind of give the court light on what's been happening.
Okay.
Two of the individuals in this case, both the complainant and the complainant's friend, both mentioned the police report, eyewitnesses to the whole transaction. Of course, one is the complainant. Both of them have cases at large with Bexar County. The former is a fugitive, so we've not been able to get a hold of her. The latter, we reached out to their defense attorney, and as of Thursday, Greg DeMary said, no problem, you can reach out to her about her involvement in this case. That was Thursday, and we intend on reaching out to that person very soon, but that is the full status update for the progress we are trying to make on reaching out to these individuals.
Have you searched the hen house, outhouse? See, he's never seen that movie.
Funnily enough, too, we have provided some materials from at least one of those people
Yes,
as well.
defense has
So
been very great about communicating with us.
we have been trying to pound this out and get somewhere on it, Your Honor.
All right, Ms. Ferguson, can you recall this for April 30th? You need to watch The Fugitive, the first.
I saw
one.
that with Harrison Ford.
Yes,
I did see it because that takes.
but
place
have
in
you seen the
Chicago.
series,
Well,
the
that's a
original?
serious question, Judge. I have not seen the series.
All right. We'll come back on April 30th.
Thank you, Your Honor.
All right, thank you.
And there is the family violence. It is the second degree. It is the one that's going to control. There are also a couple of simple possession cases that I have no doubts that we can resolve. Obviously, the second degree felony is going to control.
All right, we'll see you all back on April 30th. And if y'all have information before then, you can always come before then.
Yes, ma'am.
All right, so where are we on this case?
Your Honor, I think it's pretty well a consensus around the treatment. The test today is going to be reported to the folks in Guadalupe. There is already a recommendation for treatment there. What we're asking is we just don't want him languishing in the jail and we have a court date up there and then they tell us the same thing. We would ask the court to consider, after conferring with probation, the court to possibly consider putting him on a scram device and or GPS. We would ask the court to consider simply amending his bond conditions for GPS and full house arrest. But we also recognize that a bond increase, would require him to go into custody today. So that's why we would be asking for that. He has his explanations in terms of what's going on. But we would bring to the court's attention that based on the court's admonishments, the last time he was here, he has completed those AA meetings. He does have proof of that. He does have a sponsor. I've had contact with his mother. I've been very, very specific, and he says that he is being helped by those meetings. I think the court could probably sense in my voice, but like I tell him all the time, I'm his attorney, I'm not his preacher, but even I'm a bit disappointed in this result today. He stands by the fact that you did not do any cocaine though this weekend, correct? And I would leave that to the. And that's what you would like the court to consider, that you're still saying you didn't do it.
Yes, sir.
So that's a kind of a roundabout way of saying, Judge, we're asking the court to not take him into custody today and allow him to have his court date in Guadalupe, which will probably end up where this court would be, if not.
When is the Guadalupe
It's May the 23rd, Judge.
state?
Judge, I think the issue here is that if we do something here with state ISF for safety, there's always a possibility that since Guadalupe County has their case open, that's going to delay anything we tried here. I think if the court were to order safety or state ISF or extend the defendant, at that point, we could possibly get in contact with Guadalupe County to let them know what we're attempting to do, or vice versa. I think it's just one of those weird situations where we're kind of in between a rock and a hard place.
And Your Honor, if I may, to kind of piggyback on what the state is saying, I would just say that just having experience, a good amount of experience in Bexar County and Guadalupe County, the counties kind of operate differently, not one any better than the other. But I would say that if that were going to be the outcome, and just in full candor with the court, as explained to the client, that's probably going to happen. It'd probably be best to let that happen in Guadalupe County, only because he's currently a resident of Guadalupe County, and they're the ones that are doing the courtesy supervision of this probation. So I'm just saying the paperwork and everything would probably be, it would just be more efficient there as opposed to.
Ms.
there.
Abrams,
If that makes sense.
how are we going to address this issue?
Your Honor, as we know, the facilities for inpatient treatment, state ISF or safety, they will have him on hold until the other cases are disposed. So I believe Mr. Hernandez Henry needs some type of treatment. I do show that he did outpatient treatment before. The drug patch, he was on the drug patch for a little while. I really do believe he needs some type of treatment.
All right,
And
so you
we're-
want to do outpatient treatment? You want to do the UA hotline? I mean, we could do the UA hotline. If there's another positive result, warrant's going to be issued for your arrest because they're going to file a motion to revoke.
Yes, and I would like to bring him back for a status check after the Guadalupe case has been disposed, or after that's seen in court at the end of the month.
Okay, so
And of course, we'll let the court know if Guadalupe, because it's in the notes, Your Honor. I've been communicating with both. You'll know if Guadalupe has made that decision to take him in, and I don't think that there will be, just like we've talked about. I don't know that it'll be making the same arguments. Matter of fact, I can tell the court I won't make the same arguments there that I'm making here. If that decision is made, then you're going to ISF or safety on the 23rd of May.
Sure.
all right. And you say it's the 23rd, right?
Yes, Your Honor.
All right. So this is going to be recalled for May 27th. His conditions of bond are going to be altered and amended to include the UA hotline. And then if he ends up testing positive, then a motion to revoke will be filed.
Okay,
And just for the record, Your Honor, you've also been fully admonished that the court has the full range of punishment still in front of them, including prison.
so Judge, are we going to go ahead and take care of the MTR? It will
No,
be the same.
this is just going to be amending the bond conditions unless you all want to take care of the MTR now.
The only reason why I am mentioning that is because it will be the same case once he goes to Guadalupe. If they're going to take him in this case, the MTR would need to.
Oh, I figured you all would withdraw it then,
Okay,
because that's what you all wanted to do beforehand, withdraw it.
yes.
So
Okay,
if Guadalupe County, if that gets taken care of, then he will let us know and you all can still withdraw it. Is there anything else he needs?
I don't believe so, Your Honor.
Stop playing softball. If you're saying that's the
I
issue.
told him I'm done.
I need to change the date to the 20th.
Well, but are we withdrawing this NPR?
Yes, the 28th.
Or not today? So when do you want me to check back in?
We're gonna bring you back on May 28th.
Well, I guess what I'm saying, if this is still open and they want to take him in, would be in the same spot.
No. They'll take him in and let them know that if they're planning on taking him in to send him to inpatient treatment, this motion will be withdrawn. So that's not gonna be an issue.
Yes, Your Honor.
But sign the reset form, and I'm sorry, that's May 28th. Mr. Porter,
Happy Easter, Judge.
happy Easter. Thank you for dressing appropriately for court.
You're welcome, Judge.
Yeah, that's a given for you, Mr. Porter. I'm liking the tie. You know, usually attorneys, they do this bland thing where it's just the bland color suits with the bland tie. Usually it's a navy suit and a red tie. So I always love sort of like the raw blues. So thank you.
Yeah, of course.
All right, so where are we on this case?
Your Honor, the Honorable Court appointed me about a
Yes.
month and a half to this case. I've reviewed the evidence with Mr. Quarles, and I've spoken to the DA about some issues that I have with the evidence, and the DA is going to be reaching out to their detective to ask him what's going on.
All right, so recall for 30 days, see where we are in discovery.
That should be enough, Judge. There might be more discovery, but if we are told anything, obviously we'll tell defense, but if there's any other type of timeline that we're given. The main concern I have is that there was a piece of evidence that was selected, but I don't believe DNA was run on it. If that was at least a concern that I shared.
All right, so maybe we need to recall this within 45 days, maybe? To see if there is DNA.
I think 30 should be enough just to get that answer, and then we'll update the court and go from there.
All right, are you employed?
No, ma'am. I was actually upon being arrested. So I lost my job because I was in jail.
Okay.
So,
All right, well, when we're doing discovery hearings and your attorney will tell you that, is there an issue with you and your employment? I usually will allow people to appear by Zoom, okay?
well, as far as like checking in and stuff like that, I've been having a little bit of difficulty because I live in Shirts. I don't know if there's anything that we can do about that. And
Checking in with whom?
with pretrial services, just because I have to ask somebody to use their car, and it's been kind of a complicated
All
thing
right,
just getting over there.
Mr. Porter, if you want to set a hearing by Zoom, and we can see what's with pretrial services. When do they definitely need you to check in? Otherwise, maybe they can do it by Zoom. Nothing hurts a failure but a try.
Okay.
All right, so you want this recalled in 30 days?
Yes, sir.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Quarles, please?
May 2nd.
All right, we'll be back on May 2nd.
Thank you.
All right, once you sign the reset form, your excuse.
Have a good day.
Thank you. Court is calling 2023 CR 10964 and 2024 CR 2671, State of Texas versus Alexandria Alvarez. Could I have parties announced for the record for the state?
Hank Lucas for the state, Your Honor.
Defense?
John Robertson, I'm on the possession case, Your Honor. Thomas Beck, I'm on the theft of the firearm case.
All right, and are you Ms. Alvarez?
Yes, sir.
Counsels, have you received all the discovery in each of these cause numbers, and did you review it with your client?
Yes, Your Honor.
Ms. Alvarez, in each cause number, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorneys? Did you understand it?
Yes, sir.
And each cause number, I'm showing you what's entitled True Bill of Indictment. Did you review those documents with your attorneys, and did you understand them?
Yes, sir.
Counsel, do you waive the reading of the indictments?
Yes, Your Honor.
State, are you proceeding on the indictment as presented in each cause number?
We are, Your Honor, in each cause.
Ms. Alvarez, in each cause number, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorneys? Did you understand them? And did you sign them in all the appropriate places?
Yes, sir.
I'm sorry, everyone, just one moment. 5 seconds. All right, sorry about that.
Sorry, Judge.
When you're dealing with contractors, you know, you gotta, when you're waiting for their phone call, you're like, please. I am learning a lot about contracting.
It's, it's that thing, Judge, where it's like, if they're at the house and they say like, it'll cost this much, you're just like, yes, okay, can you start now?
Yeah. Well, being in a hotel since August, even though I love the hotel, it's like, I'm so ready to get back home. So whenever I see, the contractor's number pop up, I'm like, I'm sorry. All right, we are back on the record. And where I left off, I was showing you the court admonishments. Did you review those with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right, and the cause number ending in 7-1, you're charged with the offense of possession of a controlled substance, penalty group 1, 1 gram to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. In that cause number, if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
In the cause number ending in 6-4, on that case, you're charged with theft of a firearm. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If the court were to grant your application for deferred adjudication in that case, if for any reason you're revoked, the court could sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, sir.
In each cases, if you have an agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
In each cause number, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, sir.
Okay. Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in each of these cause numbers? Counsels, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, sir. She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, sir. Yes,
Ms. Alvarez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes, sir.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, I'm showing you the plea bargain agreement. Did you review that with your attorneys? Did you understand?
Yes, ma'am.
In each cause number, the cases are to run concurrently. There's a $500 fine. State is recommending deferred adjudication. They are taking in consideration County Court 2 cause number 715921 and 2023 CR 10963. And in the cause number ending in 7-1, there's to be restitution to Live Oak PD for drug testing. And in cause number ending in 6-4, there's to be restitution to Julian Scales, SCALES, if any. Did you understand those to be the pleas in each of the cause numbers?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor. The only thing I would add is in the cause number ending in 6-4, the theft of the firearm case, she's forfeiting her right to the firearm.
All right. And in that cause number, do you understand as a part of the plea bargaining agreement, you to forfeit the firearm?
Yes, sir.
In each cause, I'm showing you the waiver of appeal paragraph. Did you review that with your attorneys? Did you understand it? Did you sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Your Honor. No, Your Honor.
Next, I'm showing you outside the agreement. In each cause number, the state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
Yes, Your Honor. I offer State's Exhibit 1 and the attachments in each cause number.
No objection. No objection.
And each cause number, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorneys? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, yes, ma'am. You said, sir.
Oh, no.
Okay.
Yeah, I'm sorry.
That's okay. Sometimes people will say that. All right, again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Right. Did you understand that today the state will be presenting evidence in the form of witnesses' statements, counsel? Witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, on behalf of Ms. Alvarez, I support to follow the agreement. I think it's important for the court to have that in September of 22. Alexandria was involved in a pretty much what was a near fatal car accident. Rolled her car down an embankment. She was ejected from the vehicle, suffered an extremely serious head injury. She had to have surgery. Was in the hospital for several months and in rehab after that. I think she's definitely a competent person. She's had some memory issues and some collateral health issues since then. I think some that may have contributed to some of her choices that's been made since then, but we'd ask the court to take that into consideration. I consulted with probation this morning. They may have a unit over there that could help her with some of those issues, maybe. We'd ask the court to follow the agreement. She wants to get her life heading in a good direction.
All right.
Judge, we asked you to follow the agreement. Maybe you can probate part of that fine. She is indigent, and 120 hours is a lot of community service, but she's going to be on probation perhaps in 2 cases.
Okay. All right. And Ms. Abrams, this is probation case. All right. Do you have any children?
I have one child.
And what is your child's age?
Braxton,
Age?
6.
And where is your child now?
He is with, he's sometimes with my mom or the other grandmother or his dad.
All right. Was Child Protective Services involved?
No.
All right. When did you start with the use of the meth?
I would say I started when I was 18. I tried it. That was the first time I tried it.
Okay. And how often have you been using it?
For like the last 5 or 6 years, I was doing it daily.
All right. So when's the last time you used? And let me just tell you this, these questions I'm asking you, I used to tell my clients all the time when I had them in Child Protective Services cases or on the criminal side, and they had agreed to probation. I always tell them, hey, just lay the truth out there, because what I'm trying to do is get you the type of help you need so you can be successful. But if you don't tell me, I can't help you, right?
Yes.
And so even if you're going to be positive for meth today, you will not have violated your probation because you're not on probation. So I need you to be 100% honest with me so I can try to get you the help that you need, okay?
Yes, sir.
All right, so when's the last time you used?
The last time I've used was September 5th of 2023.
All right, so if you're drug tested today, is it going to be clean?
Yes, sir.
All right, so we're going to do a drug test, and then we're going to come back and finish with sentencing, okay? Probation, could you do a drug test, please? All right, so just have a seat and then we'll take it up.
Okay, thank you.
You're welcome. All right, we're back on the record in 2023 CR 10964 and 2024 CR 2671. State of Texas versus Alexander Alvarez. The court has been informed that the test was negative. I'm very happy for you and proud that you're sober.
Thank you.
All right, yes.
Judge, I just wanted to follow up with that a little bit for the court's information. I'd noticed a tattoo on Alexandria's arm. She has a 1 day at a time tattoo. And when she snapped that date off on September 5th, that's my offense date. And I said, that's a sober date when she had it like that. So
Awesome.
he was in jail until January, finally got out on bond, went straight to Haven. She's been in their inpatient program since January 17th and has got 17 more days before she graduates that program. So she's working things without being told to work things.
Awesome. That's fantastic. I'm proud of you. And yeah, one day at a time, 1 minute at a time.
Yeah.
All right. All right. So this is what the court is going to do in each cause number. In each cause number, the court is going to sentence you to a $500 fine. That fine will be probated in each cause. The court will sentence you to 4 years deferred adjudication in each cause number. The state was asking for 5. Let me just tell you why I'm giving you 4, because you've been doing work. And sometimes, even though these are crimes, sometimes you want to say, yeah, I did something good and somebody acknowledged it. So that's why I'm giving you 4 years deferred instead of 5, okay?
Thank you.
It's going to be 120 hours of community service restitution. Each case will run concurrent. I'm going to order parenting classes. Once you complete the parenting classes, the community service hours in each cause number will be deemed satisfied. You're to continue with inpatient treatment at Haven for Hope. So are they having you look for employment yet or no?
No, ma'am.
All right, so proof of employment within 30 days of release from Haven for Hope, inpatient treatment.
Yes.
There should be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. And the cause number ending in 71. You are to have restitution to Live Oak PD for testing. And in the cause number ending in 64, you are to forfeit the weapon. Restitution, if any, to Julian Scales. With regards to restitution in each cause number, if you all think that the restitution is not appropriate, you can come back and we'll have a hearing on that. Field visits upon release from Haven for Hope until further notice. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am.
And each cause number, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorneys? Did you understand it and did you sign it?
Yes, ma'am.
And each cause number, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. To be successful in this court, communication is key. If you have an issue or you feel like, hey, I'm about to throw up my hands, call your probation officer. If you feel as though they're not addressing your issue, you can always come back to court, okay?
Okay.
Yes.
Sorry. Judge, we have one case being TIC out of county.
Yes, I've already signed the dismissal for that.
And then could we put one more thing on the record, Judge?
Sure.
I want to ask that if you could order that the weapon be returned to the complaining witness, Julian Scales in this case.
All right, could I see the file? What cause number is that ending in?
It's in the one that ends in 964, Judge.
All right, could I see the file ending in 964? In that cause number, the weapon is to be returned to its rightful owner.
Okay, thank you, Judge.
So because I don't know, I don't have any information
Yes,
before me who it actually belongs to.
Yes, ma'am.
So I will say that the weapon is to be returned to its rightful owner.
Thank you, Judge.
You're welcome. All right, is there anything else?
No, Your Honor.
All right, good luck to you.
Thank you.
You're welcome. Have a great one.
You too.
Final outcome. Alvarez gets 4 years deferred adjudication in both felony cases, with treatment, parenting classes, restitution, and strict supervision. The judge clearly rewarded real progress in recovery, but now she has to keep proving it. Like, share, comment, subscribe.